testimony with anyone but in the case of Mr. Brown, the parties, in the case of the plaintiff, the attorney. All right, at this time, the plaintiff may go ahead.
Your Honor, would you like me to stand or can I be seated?
You can be seated, that's perfectly fine.
Your Honor, the Tucson City Court has been plagued with a number of incidents involving so-called First Amendment auditors, Mr. Brown included, who claim that Arizona Supreme Court Rule 122.1 does not apply to them, and that they have an absolute First Amendment right to record proceedings in Tucson City Court without being required to follow the commands of that rule. Based on a number of such incidents that took place more than a year ago, Tucson City Court Administrator Christopher Hale obtained an injunction against workplace harassment against Mr. Brown, in particular on January 9th, 2018. That injunction was upheld in an appeal to the Superior Court on December 26th of 2018 and by Judge Richard Gordon, and I have a copy of that ruling in my possession and would provide to the court to take judicial notice of that ruling. But essentially, in that ruling, there's a wide variety of facts and law that are discussed. The court takes particular note of Mr. Brown's disruptive conduct in the city court, and also essentially filed a short amendment to the injunction against workplace harassment that was obtained last July, requiring Mr. Brown to comply with the provisions of Rule 122.1c anytime he attends Tucson City Court. Subsequent, well, just as a quick basis, Rule 122.1 not only prohibits presenting or videotaping courtroom proceedings, it also prevents any party from recording anyone while inside a courtroom without that other party's consent. And I misspoke there. Courthouse side includes basically the entrances, the lobbies, the hallways, all the rest of it. In response to some of the issues that have been presented by First Amendment auditors here as well as elsewhere in Arizona, the Arizona Supreme Court has specifically delegated some additional rulemaking authority to local judges and magistrates in response to Rule 122.1. And on June 5th of this year, Judge Tony Riojas of Tucson City Court filed the new amended proceeding that prevents any party in Tucson City Court from recording anyone in Tucson City Court without obtaining that person's prior written consent and showing that consent upon entering the courtroom. Mr. Brown has continually and repeatedly indicated his intent to violate the standards and rules established in Rule 122.1 and subsequently by Judge Riojas' order of June 5th, as soon as the present injunction expired. So we're here again, not to do anything that extraordinary. We're just here to ensure that if Mr. Brown enters Tucson City Court, the entire time he's there in Tucson City Court, he's going to be in compliance with Supreme Court Rule 122.1 and with Judge Riojas' order of June 5th, 2019. There are no real First Amendment issues at play here. The courts have long held in a number and variety of cases that even prior to its modern First Amendment jurisprudence, that there is no First Amendment right to record proceedings in courtrooms, that the First Amendment rights with regard to citizenry in courthouses and courtrooms is a right to attend those proceedings. Subsequently, when the Arizona Supreme Court adopted sort of its structured rules of jurisprudence and reasonable time, place, and manner, content neutral restrictions, etc., courts have repeatedly, under the more modern ruling, held that bans on videotaping and audio recording in courts all across the country are valid restrictions of First Amendment activity. So we're not here to create any new law, and we're not here to ask Mr. Brown to do anything that he's not otherwise required to do by Arizona Supreme Court rule or by Judge Riojas' order of June 5th, 2019.
All right, thank you very much. Mr. Brown, did you have an opening that you wanted to give?
Yes. So,
I do need to remind you that you will have an opportunity to testify if I find
Yes.
that there has been a prima facie case.
Yes.
So this is what you anticipate the evidence to show, but you may.
yes, so they're going to still give their evidence, and then I get to respond after I question Christopher Hale, correct? So this ain't the question of Christopher Hale, this is just to give my opening.
Yeah, and if you prefer to give your opening after the plaintiff's case has been made, you may give an opening now, or you may give it after their case.
Oh, I'll wait till after they present the case, and then I'll give it
All
up.
right, very
Yes.
good. That's your choice, sir.
Yes.
All right, you may go ahead and call your first witness.
Your Honor, I'll call Christopher Hale.
All right, and Mr. Hale, do you swear or affirm to speak the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, please watch your step as you come up to the witness stand. All right, you may go ahead.
Mr. Hale, can you tell the court what you do for a living?
I am the Tucson City Court Administrator.
And in that capacity, could you briefly describe to the court what those responsibilities entail?
I am responsible for the functioning of the court, all aspects of the court, with the exception of the legal decisions made in the courtroom by a judge.
And is it, can you describe to the court your familiarity with Arizona Supreme Court Rule 122.1 and what it provides inside not only the courtrooms that you supervise, but the courthouse that you supervise?
I've read it numerous times. I was a member of the Arizona Supreme Court's working group on recording in the courthouse, specifically dealing with Rule 122, but more precisely Rule 122.1 and the revisions of that rule and the development of the model administrative order that has been provided to all courts in the state of Arizona.
And in your supervision of the city court, have you had any occasion to come across Mr. Brown?
I have.
And in your contact with Mr. Brown, does he consistently and assiduously follow the strictures of Rule 122.1?
He has not.
And can you describe to the court just a few of the incidents that have taken place, including those from a year ago?
My contact with Mr. Brown started on May 30th when he and Anthony Potter and Vernon Peltz were recording individuals in our public services lobby. I received several complaints from members of the public and from my staff that they were being recorded. I had already advised our staff that they did not need to consent to being recorded because we had had a previous person on May 6th who was recording staff, and we had coordinated with the city attorney's office, and I had talked to David Withy in the Arizona Supreme Court's Legal Services Division to ensure that Rule 122.C2 applied to court staff. We provided guidance that said they did not need to comply or to consent to being recorded, and they expressed this desire to not be recorded to Mr. Brown, Mr. Potter, and Mr. Peltz. The public, I don't think, is quite aware of the rule.
Have you had occasion to make sure that Mr. Brown's been provided with the rule and that
Yes.
he's aware of it?
Yes.
Can you just?
And Mr. Brown has photographed our rule, he has photographed our signs, he has received the in-chambers order from Judge Gordon. There is video of Mr. Brown and Mr. Peltz in a van going through that order line by line, making fun of it, and saying that they didn't have to comply with it.
Is there any doubt in your mind about whether Mr. Brown understands the contents of Rule 122, 122.1 and the associated rules involving videotaping or video recording inside
Well, actually, I think, Mr.
Premises in
Brown,
Arizona?
there is a little doubt, not that he doesn't understand Rule 122.1. However, he does confuse 122 and 122.1 because,
But
but there's no doubt that he knows that he cannot record people without their consent.
and has he also been provided a copy of Judge Riojas' order of June 5th?
He has not. He has been prevented from entering our courtroom unless he has a court date. And I brought a copy with me with court's permission. I would be glad to provide him.
Okay. Despite the awareness of Rule 122.1, as Mr. Brown indicated, either in any public forum that you're aware of his intent to violate that rule as soon as he's able to return to city court?
Yes. Two instances. One video posted where he was at, I don't know if it was a swap meet or something. It was in the daytime. I have the video. He clearly states that the only reason he was not going back to city court and recording was because he had an injunction, and that once the injunction was up, he was free to come back in and violate, he didn't use the word violate, but he was free to come back in and record, and that Rule 122.1 did not apply to him because the injunction had expired.
Has Mr. Brown also confronted you outside of Tucson City Court recently and indicated his desire to return to city court and continue to violate Rule 122.1?
He did so on June 25th, when I was walking over here to...
Can you describe the circumstances of that confrontation to the court?
Sure. I was walking over to Pima County Justice Court to review a file, and I encountered by accident, or I did not know they were there, Mr. Brown, Mr. Gonzalez, and two other unknown individuals. Mr. Brown asked me if I was happy for him because his injunction had expired and that he would soon be back in city court.
And did that indicate to you an intent by Mr. Brown to violate the provisions of Rules 122.1 and 122?
My assumption was that he would be back in the court, video recording based upon that statement and other statements he has made in his videos posted on YouTube.
And is it true, Chris, that Mr. Brown's statements about Rule 122.1 are all premised on the idea that Rule 122.1 is a violation of his constitutional rights?
That amongst other things.
So it's not a question of understanding the rule, it's a question of him thinking that the rule doesn't apply to him because he has constitutional right to violate it?
Yes.
No further questions, Your Honor.
All right, Mr. Brown, this is your opportunity to ask the questions that you have of Mr. Hale.
Oh,
Now,
yes.
as I said, you will have an opportunity to testify if we get to that point.
Yeah.
So this is an opportunity for you to ask questions.
Yes.
And we will make sure that you have the right to testify on your own behalf separately. Okay, go ahead, sir.
Okay, thank you, sir. All right, so Christopher Hill, so you state that I intended to violate rule or that I intended to come and record you. In your statement, you said I was trying to record you, correct?
In my petition, I said you had recorded me without my permission on two separate occasions. What I just said was that, based upon the video I saw, you intend to return to city court to record. I don't know who you intend to record.
Okay. Is it against Rule 122.1 to record you?
Without my permission, yes.
Okay. In the last, we had several meetings before. This ain't our first time in court, correct? Two
This is not
injunctions.
our first time in court.
Yes. Okay. Injunction against harassment. You put that against me. That's the first one you put against me. Not workplace, but the first one you put harassment against.
That was a mistake, yes.
Yes, but it went through all the way through court, and I had to appeal it. And this went to appeals court, right?
It was appealed, yes.
And what happened to that? It got thrown out or
We
what?
did not respond, and it was turned down because there weren't two incidents. But
Oh.
again, that was a mistake, and we never contested it.
But
Neither did you.
did this court? Well, we went to trial, obviously, and I contested it with appeal. So you would
Well-
say I didn't contest it? I contested it
If
previously.
I'm not, Mr. Brown, if I can answer, if I'm not mistaken, you did not show up, and that was a default ruling by the judge.
Did that not go to court?
I don't know, I'm just telling you, as far as I know, you did not show up.
If I
And
didn't
that
show
was
up,
a
how would I
default.
appeal it, sir?
I don't know.
I just don't get this.
I'm not sure what he's asking. to be
The
honest.
injunction against workplace harassment is materially different than injunction against harassment, Your Honor. What we're seeking in this case is an injunction against workplace harassment, so I think this line of questioning is irrelevant.
As to the extent of prior litigation, I'll allow some leeway with this, but Mr. Brown, if he doesn't know the answer, you're going to be stuck with that he doesn't know, and you'll have an opportunity to challenge that later, okay?
Yes.
All right, so you can, if the answer is that Mr. Hale doesn't know, then you're going to be stuck with that answer.
All right, so let me read the ruling on real quick and see if, is this the ruling? Appellant's act of harassment was neither directed at appellee or he did not gauge two acts of harassment at the appellee. As a result, the trial court erred in entering the injunction against the appellant. Having found the trial court erred, it is not necessary to research the merits in the appellant's other arguments based on the foregoing. Correct?
I've read that, yes.
Yes, so this is correct. So you was at this hearing and this was the appeal.
Again, if I'm not mistaken, and I could be because I've been to several of these, if I'm not mistaken, you did not show up for the contested hearing and a default judgment was entered.
Okay, all right. I'm going to move
Which you
on.
appealed. You appealed the default judgment.
Yeah. Okay, so
But
I'm
again,
going to move on.
That
I'm
was an
just,
injunction against harassment, not an
Correct.
injunction against workplace
but
harassment.
it did go through trial, and then that's why I appealed it, and I won an appeal. Okay, that's all I'm getting at. Okay, so the next thing, you say I don't understand Rule 122. Do you think you have a good understanding of Rule 122 and 122.1?
I do.
Okay.
I would like it in front of me before I answer the question.
Okay, I do have a copy if you would like it. Let me get you a copy. I brought 3 copies. I have no problem with that, sir. Can I approach the bench?
You may.
I'm going to show you what I'm giving them, sir. The same thing that I just approved with them. There's 2 pages. One is 121 and 122. I'm sorry, and one is 122.1.
Okay.
Okay. Do you recognize that as 120? As 120?
Yes, I recognize these as the court rules.
Okay. All right. So, can you tell me where in this rule does it say that I can't record public officials inside this building?
Rule 122.1, C2, outside of the courtroom, in areas of a courthouse other than courtrooms, no one may photograph or record an individual without that individual's express consent.
Okay. And then, and so that falls back on the word individual or person, huh?
Yes.
Okay. So, in our last meeting, you gave the definition of, give me the 121.2 definition of the word person or individual.
Your Honor, this calls for, basically the rule itself has written, you can take judicial notice of it. I don't think Mr. Hale has to interpret.
I want him to read it, just to read it.
If there is a definition there, you can read that into the record, but I will take judicial notice of the rule as written.
So do you want the rule, you want the definition of a person from Rule 122?
Yes.
Okay. A person includes an individual and organization except the court. And if I may, Your Honor, I know where he's going with this, and the Arizona Supreme Court has already provided guidance that says that a person is not an individual.
Okay.
Okay. What does accept the court mean?
Organization except the court. It goes back to.
It says it replies.
Let me answer the question, please.
Yes.
Okay, so it goes back to your question about why the court can record people on our security cameras, because the court is accepted in that rule.
Okay. As a layman, this is saying again, let me reread it. A person includes any individual of any organization. And they're talking about me recording somebody, and then it says, accept the court.
All I can tell you is what the Supreme Court Legal Services Division said.
I'm asking you what this says, sir. This is Rule
You just read
120.
it.
Okay, so in our last meeting, you and your counsel stipulated that you are the court.
No,
You did not? You don't think you're the court?
no.
So in our last meeting, of course, in this courthouse, you during that half hour with Patrick Gonzalez, you and your attorney didn't say we stipulate that we are the court.
I don't recall that.
Okay, so are you saying that you're not the court?
I am an employee of the court.
Yes, and that's what they're talking about. Are they talking about the courthouse as the court? The courthouse I can't record the courthouse? Is that what they're saying?
They're saying that you cannot record an individual without their express consent
Yes.
in the courthouse.
Individual is someone except the court, correct?
No. You know, I wish I had brought
Okay,
that.
I'm gonna have to get some judicial thing, because I'm reading it totally
No,
different.
Mr. Brown, I think that you've established that the two of you disagree as to how the rules are going to be read in relation to one another, and you'll have an opportunity to testify as to your interpretation of that.
Okay,
But I think that it's clear that Mr. Hale disagrees with the interpretation that you have.
yes, and okay, back to the definitions. The first time we talked, you said that didn't apply to Rule 122.1, because that was definitions in 122, correct?
No,
Because that's the definition in 122.
no,
Okay, do you admit that these rules apply in 122 to 122.1?
no. Rule 122 has certain definitions in there.
Okay,
It then says that any definitions in there that aren't covered by Rule 122.1 are in 122.
yes, okay. So can you read, on 122.1, can you read on B, on the definitions, read number 3?
Cover. And coverage refers to a person's use of a recording device during a proceeding.
Okay, in 122.1, I asked you, on definitions B, you're on the wrong page. On
Well,
one,
not in 122.
yeah, 122.1,
So you want me to read what?
B, under B definitions, number 3.
Other definitions. This rule incorporates other definitions found in Supreme Court Rule 122.B.
Okay, so 122.B is what we're talking about. Now we'll go back to 122.B, and you do agree that 122.B says accept the court under the definition of individual.
It does.
And you still say you're not the court.
I am saying that the definition of an individual does not include employees of the court. The court is
So
an
I
organization-
can record employees of the court. Is that
No,
correct?
You cannot.
Okay. Are you the employees of the court is also the court, correct? All your employees
They're
working for
employees
you?
of the court.
Yes. So they are also the court.
It doesn't matter how many times you ask me the question, Mr. Brown. The Supreme Court, all the legal guidance that I have gotten
Okay.
state that
I'm asking you what this
cannot
says, sir.
record. And I'm not gonna change my mind. I follow the legal guidance that I have been given by competent legal authority. You cannot record an individual in the courthouse without their express consent.
And an individual means what?
Anyone.
Except the court.
Your Honor,
Okay, I will.
I would like you to take judicial notice of what the definition of individual is, and you're the one that ultimately has to make that call in this case.
At this time, I'll sustain that as to asked and answered, that he has given the answer, and you'll have an opportunity to provide your definition, Mr. Brown. So, okay, you can move on.
Yeah, the definition is in the right here, and he already read it. So I don't see how anyone can interpret it differently. Anyone knows how to read has to read it the way a layman sees. Okay, let me ask you a question. Are these really made for a layman? Are they made just for people in law? The
Those
rules.
are made for everyone.
Yes. So could you see how a person can make that mistake? If it says accept the court, that would make me think that I can record the court. Would you see my side?
No, because you got a ruling from the Arizona Superior Court in Pima County that detailed out the definition of an individual and specifically told you in your appeal, you may not record individuals without their express consent, and that it does apply to court employees.
Okay, I'm gonna go back
Did you
to,
read that?
yes, sir, I did. So I understand your answer. Now, I'm gonna go back to this, thing I read to you earlier. Having found the court erred is not as necessary to reach the merits of the other arguments. That was in the other arguments, correct?
That's,
Yeah, and, this was
I
asked and answered.
previously objected on the grounds that he's reading from a different case here.
I understand.
This is
that.
same-
It will go to the weight of that, but that has been asked and answered.
Yes. So I didn't get to address them because it was ruled on the court erred. So I didn't get to address that issue. And that was in there, correct?
no.
All right. So we are not going to get no honesty, so let's continue on.
Your Honor, that's
Okay.
not a question.
No, that, we struck it.
All righty. So let's go back. You tell me everything that I did to violate Rule 122-1 or 122 on the two incidences you talk about. One on January 2nd and one on January 24th.
One on January 2nd, you recorded me without my permission in the courtyard of Tucson City Court, outside of a courtroom. On January 24th, you were at court in courtroom number 2 for a hearing or an arraignment, and a police officer tried to effect an arrest or asked Mr. Gonzalez to step outside. You then inserted yourself into that conversation and disrupted court operations. Both you and Mr. Peltz ended up standing up and making speeches in the courtroom, which caused the city attorney to have to stop what he was doing, informing defendants of their rights. I'm sorry.
Okay. You can go ahead, sir.
Where he was informing defendants of their rights and making plea offers, you disrupted that. I happen to occupy 2 positions that allow me to determine what is disruptive to court operations. I am the clerk of the court for a limited jurisdiction. As a court administrator, I am also the clerk of the court. And if you read Rule 122, it allows both the clerk of the court and the court administrator to determine what is disruptive to court operations.
And what was, okay.
And then again, as long as we're going through it, I'll just.
Okay, so on January 2nd, did you not give permission to, and did a 45-minute interview on January 2nd with Mr. James Freeman?
Not with Mr. James Freeman.
James Springer. James Freeman's is his YouTube account, and he goes by James Springer, correct?
I gave permission to James Springer,
Yes.
not to Mark Brown.
So when you said I give
And we did that in
permission,
my private office, by the way.
pardon me?
We did that interview in my private office, by the way.
Correct. Correct. Okay. And during that interview, how long the interview lasted? Do you know that?
I have no idea.
Okay. What were the signs prior to May 30th, 2019? What signs said in the courtroom? What signs did you have about recording then? Prior to May 30th, the first incident.
May I have a moment
Your Honor, I
here?
think this is irrelevant in terms of what Mr. Brown is not entering the courtroom for the first time. Mr. Brown's the person here who's handing out copies of the Arizona Supreme Court rules. I don't think this is relevant in any respect.
I will sustain that.
Excuse me. Your Honor, may I have a second? I seem to be
Yes, you
missing
may.
my phone. I want to make sure I know where it's at.
It's right here.
Okay, got it.
Okay.
Thank you. We're good.
So yeah, he has to answer the question, right?
No, I sustain the
Oh,
objection, but you
so-
can ask
so-
more questions.
Well, them rules were the same rules that's in effect at the time on January 2nd, correct?
No,
Okay, what did it say on January 2nd? What the rules say about recording?
I believe on January 2nd, the rule had been changed so that there was no recording in room 401, in room 104, in room 114, our domestic violence area. I believe there were 4 areas.
Okay.
You took a picture of it.
Yes, I'm asking you what they said,
Oh,
though,
I
sir.
can't remember verbatim.
Can you basically say
I
what it
just
said?
did.
So it says no recording at all, or?
The presiding magistrate, Rule 122 allows people to record in areas of a courthouse outside of a courtroom. That means you can record the roof, the floor, the signs. As long as you're not recording people without their express consent, you can record in the courthouse. Under Rule 122.1, the presiding judge or presiding magistrate has the authority to place areas of the court off limits to recording or prohibit recording. Based upon your actions in May, the presiding judge decided that there were areas that he was going to prohibit recording in. And he listed those areas. We changed our signs and put that up. You took pictures of it and made fun of it.
Okay, then why did you change the signs?
Because the presiding
That's
judge
an answer.
decided that you weren't following
That's
the
an
rules.
answer.
That's an answer, that's sustained.
Okay. Okay, during that interview with James Springer, you admitted that you put your face on the internet from prior public relations things, but you said that's different because you don't control the narrative, and that they called you a tyrant when you polled the victims.
Irrelevant, Your Honor.
Sustained.
Okay, well, this is on January 22nd, and that's what they talked about inside the room. Okay, so you're saying that I'm not following Rule 122-1, but I'm thinking I did because I think that when they say accept the court, that means accept the court.
Your Honor, it's
Correct.
testimony, not a question.
You'll have an opportunity to testify to those things if we get to that. But
Okay.
that's sustained.
But so the only thing that you're saying I violated the 122 is filming you. That's all you mentioned on your papers here, correct?
No, those are the only things that I listed. on
Okay,
the-
I just want to talk about things you listed. That's what
I
we're.
would say